Welcome back to the Freedom Unchained channel. Another lesson from George Gordon, Common Law School. If you guys haven't checked out this course from the beginning, go to the playlist and check it out from the beginning. If you're really interested in learning what law truly is and funnel through all the lies of the government like normal, please subscribe to the channel and hit the bell notification so you can get the next video upload. Please also share this video around. Let's start getting the word out for freedom. Of course, leave a comment so the algorithms will help spread this video around. And also support the channel by going to the new page that I set up to help guide the projects that I wish to be working on. So I hope you guys come over there and join me or support me in some way. And let's get to George Gordon, Common Law School.
And the Supreme Court says, nope, we don't want that. So let's read on. We're on page 268, I believe, here. The Border Patrol conducts 3 types of surveillance along inland roadway, all in the asserted interest of detecting the illegal importation of aliens. So their purpose then is to catch wetbacks. Permanent checkpoints are maintained at certain nodal intersections. Temporary checkpoints are established from time to time at various places. And finally, there are roving patrols, such as the one that stopped and searched the petitioner's car. In all of these operations, it is argued the agents are acting within the Constitution when they stop and search automobiles without a warrant, without probable cause to believe the cars contain aliens, and even without probable cause to believe the cars have made a border crossing. The only asserted justification for this extravagant license to search is, notice those words, extravagant license to search, is 287A3 of the Immigration and Nationality Act, 66, Statute 233-8 U.S.C. 1357A3, boy, what a mouthful that is, which simply provides for warrantless searches of automobiles and other conveyances within a reasonable distance. It provides in a reasonable distance. Well, what if the Attorney General said a reasonable distance from the border is 1,000 miles? What if he said 3,000 miles? Well, then they can search any automobile they want anytime, any place, can't they? In other words, they can just set their own code and their own rule to make whatever search they want to make. Well, that's insane. We can't have our police making their own rules. We, the people, are going to make the rules. Within a reasonable distance from any external boundary of the United States is authorized by regulations to be promulgated by the Attorney General. And here's the Attorney General's Regulation 8 CFR. I want you to notice 8 CFR, underline that in your book. Because that's called the Code of Federal Regulations. And the Code of Federal Regulations doesn't apply to citizens. It applies to those juristic persons to which that Code of Regulations is applied. Mainly, government employees. Yeah, it applies to government employees, but it doesn't apply to me. Doesn't apply to you. Probably doesn't apply to you. And boy, they use that CFR. They give people tickets in national forests. They just use that CFR as if that's the Constitution and the main law of the land. Well, anyway, the CFR defines reasonable distance as within 100 air miles, and that's written by a bureaucrat, so he just put in there whatever number he wants from any external boundary of the United States. The Court of Appeals for the Ninth Circuit recognized that the search of the petitioner's automobile was not a border search, but upheld its validity on the basis of the above-mentioned portion of the Immigration and Nationality Act and the accompanying regulation, 452 Federal 2nd, 459 to 461. So the U.S. Supreme Court says we granted certiorari, I think that's the way that's pronounced. We have about 15 people here trying to certiorari and certorti, and we've elected certorti, I believe is the way that's pronounced. 406 U.S. 944, to consider the constitutionality of the search. Now remember what I told you. The search is a constitutional issue each and every time it occurs. Now the court doesn't accept every case that's appealed to it on the basis of the Fourth or Fifth Amendment, but it can be appealed on that basis, and this guy appealed. This was his only thin thread of hope. I always recommend that a student put in 30 motions and challenge every constitutional issue from searches and seizures and juries and common law issues and just on and on. This guy's got one hope of winning. No claim is made, nor could it be, that the search of the petitioner's car was constitutional under any previous decision of this court involving the search of an automobile. That's kind of telling them where the spades lie, isn't it? No claim is made, or could one be. You might have searched the guy's car, but listen, you didn't get it out of this court. Not the way you did that one. It is settled, of course, that a stop and search of a moving automobile can be made without a warrant. That narrow exception to the warrant requirement was first established in Carroll v. United States, 267 U.S. 132. That's called the exigenic search. So, yeah, the policeman can do an exigenic search, but he still has to have probable cause. He still has to be able to go get the warrant and has to be supported by an affidavit. In this case, who's going to sign the affidavit? Who's going to claim that there's marijuana in that car before these fellows searched and found the evidence? Put another way, what that boils down to, we'll just search people randomly, and if we find something in there, we'll use it against them, and if we don't, well, then we'll just let them go. That's the kind of police state mentality that comes from Poland and Czechoslovakia. It doesn't come from the United States, and it doesn't come from our Constitution, and it doesn't come from our Bill of Rights, and it doesn't come from our Supreme Court. It does come from some citizens in America who would like to see that kind of broad search power. The court in the Carroll case approved a portion of the Volstead Act providing for warrantless searches of automobiles when there was probable cause, you have to have probable cause, to believe they contained illegal alcoholic beverage. Well, in the Carroll case, they had a tip-off. They had a man who said, yeah, I'll sign the warrant, and I saw him loading the booze in the car, and they're on their way. So they had probable cause in the Carroll case. The court recognized that a moving automobile on the open road presents a situation where it is not practicable to secure a warrant because the vehicle can be quickly moved out of the locality or jurisdiction in which the warrant must be sought. So, Carroll has been followed in a line of subsequent cases. Now, the Carroll case is in these first 5 books. You need to read the Carroll case in its totality so that you can understand the warrantless or the exigenic search, as it's called. But the Carroll doctrine does not declare a field day for the police in searching automobiles. Now, I saw in the paper the other day that Supreme Court loosens Fourth Amendment search requirements. And based upon this piece in the paper, the Supreme Court has ruled that the police can just search your car anytime they want. Poppycock. Can't do that. The court never made any such ruling. Always make sure that when you see it in the paper that you follow it up by reading the case. Well, automobile or no automobile, there must be probable cause for the search. As Mr. Justice White wrote in the court, for the court in Chambers v. Maroney, 399 U.S. 42, in enforcing the Fourth Amendment's prohibition against unreasonable searches and seizures, the court has insisted upon probable cause as a minimum requirement for a reasonable search permitted by the Constitution. Okay? Probable cause is the minimum. It isn't the maximum, it's the minimum. You got to have that much. There's much more, but you got to have at least that. Without probable cause, don't even talk to us. In seeking a rationale for the validity of the search in this case, the government thus understandably sidesteps the automobile search cases. So here's your government lawyers. They don't go to automobile search cases. They're going to go over here to police powers, off point. That's right, off point. The government, in this case, was off point when they quoted Colonnade and Biswell. Now I'm going to show you why. Instead, the government relies heavily on cases dealing with administrative inspections. That is, inspections made that are done by consent. So if you've got a police power, you have a police regulation in a regulated enterprise, the government then, what do? They go and they get those lines of cases, which I'd sit here and say, well, certainly you can go inspect and search this particular company. It's a corporation. Certainly you can demand that corporate entity's business records and bring them in and analyze them. Well, there's no problem with that. But there's a big difference between a corporation and a citizen. But these cases fail to support the constitutionality of this search. Remember, each case is decided on its own merits. In Camera versus Municipal Court 387 U.S. 523. Now there's an important case for you to go research. You have to remember there's hundreds and hundreds of cases, but these two cases called Camera and C, it's also C versus City of Seattle, they're two key search and seizure cases that you need to pick up, and I think you're going to find those in the search and seizure law report. The court held that administrative inspections to enforce community health and welfare regulations could be made on less than probable cause to believe that particular dwellings were the sites of particular violations. Well, can the fire department come in and inspect an apartment house? Well, certainly the apartment house is licensed to conduct business. It affects a public enterprise. It's there for profit or gain. It affects and is controlled. It affects the public interest, and it is controlled by the police power. So the fire marshal comes in and says, hey, I want to inspect. Okay? That's one class of persons that can be inspected. Yet the court insisted that the inspector obtain either consent or a warrant supported by a particular physical and demographic characteristics of the areas to be searched. Even there, a person has some constitutional rights called civil rights passed by Congress. You can't just walk into a warehouse or a business, even if it's a corporation, without some safeguards under the Fourth Amendment. They're not as stringent as probable cause, but still you've got some protection. So the search in the present case was conducted in the unfettered discretion of the members of the Border Patrol who did not have a warrant, probable cause, or consent. So you got to have a warrant, probable cause, or consent, or you don't have a lawful Fourth Amendment search. Well, what happened? Sometimes they search without a warrant. Sometimes they have a warrant without probable cause. Sometimes they have a warrant without probable cause and without consent. They need your consent. In some cases, they do. So whenever the warrant is at your front door, always challenge the warrant. Sir, I'm not letting you come in. I'm not agreeing that this warrant is true. Make him push you out of the way. Now, don't resist. Don't get killed. Don't pull a gun. Don't go crazy. What you have to do is to make an effort to assert your right. Rights that aren't asserted are assumed to be waived, and you have to be the belligerent claimant in person. Okay? So here you are, the belligerent claimant. No, sir, you can't come in. That warrant fails, and I demand that you get another warrant and blah, blah, blah. Now, he pushes you out of the way. He finds something in the house. The warrant's looking for an Uzi submachine gun, and they find marijuana. Can they then use the marijuana against you? No, not if you didn't let them in. But if you said, oh, this is a search warrant. Oh, gosh. Oh, Margaret, they've got a search warrant. Come on in, fellas. Go ahead and search. Now, they're looking for Uzis, but they don't find Uzis. They find heroin. Now they're going to use the heroin against you because they have your consent to come in. Don't ever give consent. The search thus embodied precisely the evil the court saw in camera when it insisted that the discretion of the official in the field be circumscribed by obtaining a warrant prior to the inspection. Let's let these fellows go get a warrant. Let's let a judge decide whether or not they're going to search. I don't want policemen just making unbridled searches. Let them go to a judicial officer first and get permission from the judicial officer, because then if the search isn't carried out correctly or there's an error, the judicial officer will recognize it. Never give consent. Even if you look at the warrant and say, boy, it looks like it's ironclad. I've had 3 or 4 warrants served on me by OSHA and EPA. All of them failed. That's right. Every one of them failed. That's how tough it is to put together a lawful Fourth Amendment warrant. 2 other administrative inspection cases relied upon by the government are equally inopposite, equally off point. Here's your government with all these high-powered lawyers in here, assistant attorney generals, etc., coming into the Supreme Court of the United States off point. Isn't that nifty? Been to law school. That's what their problem was. Or what they're trying to do is they've been given the assignment and they know they're wrong, and so they've got to do something, and so they're arguing their position from the left side. So oftentimes a lawyer, he may not be dumb, and he may not be off point either. He's just forced to come in because he knows that based upon the Supreme Court decisions of the past, he can't rely upon automobile search cases. And so he goes over and he gets these other cases from administrative law, which is another subject matter. and then goes into the Supreme Court, and then they say, hey, dummy, you're off point. These cases don't apply to this kind of a situation. And that's what you're looking for, because, you know, if you can't stay on point, if you can't get the right class of cases, you can't sit here and argue police power cases in a search and seizure circumstance any more than you can argue administrative law cases when you're in a search and seizure circumstance, or vice versa, or any combination. When you're talking about Fifth Amendment, you've got to get Fifth Amendment cases. When you're talking about police powers, you've got to get police power cases. When you're talking about traffic, you've got to get traffic regulation cases. That's one of the biggest complaints that judges have that I've talked to. You'll sit down at lunch with a judge from time to time, and they'll say, you know, you pro ses can't hold an intelligent conversation. You get into the courtroom and you're talking about apples and oranges, and the subject matter is bananas. And I agree. Boy, I'm the first one to recognize that in my early days I couldn't stay on point for 5 minutes. Now, what we're trying to do is to teach people how to go into that courtroom, and we're talking about search and seizure. There are 15 or 20 different settings for just the one subject matter of search and seizure. Automobiles, houses, businesses, individuals on the street, personal searches, searches of third-party interests like banks. Can you get a search warrant to go into a bank to look at your bank records? You know, third-party actions. And all of those things are searches and seizures under the Fourth Amendment. But you can't go in and claim that the IRS doesn't have a right to search because they didn't have a warrant, and it's an exigenic search pursuant to Carroll, because Carroll is so off point and off the wall and out to lunch, it's not even appropriate to bring up the Carroll case when talking about your bank records. You follow that? Okay, let's go on. 2 other administrative inspection cases, I'm reading down here at the bottom of page 270, relied upon by the government are equally inopposite, and they're called Colonnade Catering Corporation versus United States 397 U.S. 72 and United States versus Biswell 406 U.S. 311. Both approved warrantless inspections of commercial enterprises. Key word, corporations, commercial enterprises. In a commercial enterprise, you don't have the same Fourth Amendment protections you do if you're in an automobile, or if you're in your own home. You know, in your own home, you've got greater protection than you would have if you're in your automobile. Engaged in businesses closely regulated and licensed by the government. Now, the court goes on. Here's your justice saying, in the Colonnade case, the court stressed the long history of federal regulation and taxation of the manufacture and sale of liquor. Wow! Gee! Colonnade Catering is a corporation engaged in the manufacture and sale of liquor. And so, here's Almeida Sanchez driving down the road, and the government says, well, certainly, we can show you gentlemen, you learned scholars here on the Supreme Court, well, look, in the Colonnade case, you said that search is all right. And so we just applied that to this Mexican driving down the road, and we found this marijuana. And the court is saying, wait a minute, dummy. This guy's not in a regulated enterprise. This guy's driving his car down the road, and you stopped him and searched him, and you didn't even claim the Carroll doctrine. Remember, early on, they didn't have permission. They didn't have probable cause, and they didn't even have reasonable suspicion. You know, at least they should have, you know, a bag of marijuana fell out of the back, and, well, then we went ahead and stopped the guy. That'd be reasonable suspicion. In Biswell, the court noted the pervasive system of regulation and reporting imposed upon licensed gun dealers, 406 U.S. at 312. So here's the government. They're saying, well, in this gun company case and in this liquor manufacturing company's case, you let us search when we didn't need a warrant. How come we can't search this guy driving down the road? Now you're beginning to see how the government attorneys were off point. A central difference between those cases and this one is that businessmen engaged in such federally licensed and regulated enterprises accept the burdens as well as the benefits of their trade. whereas the petitioner here was not engaged in any regulated or licensed business. If Mr. Sanchez had been licensed to haul marijuana, they didn't need a warrant. But you see, Mr. Sanchez wasn't licensed to haul marijuana, was he? He didn't give him his consent or permission. He didn't volunteer into a regulated enterprise. Now you're going to say, oh my God, that can't be. You mean the Supreme Court would turn that marijuana smuggler loose because he didn't have a license? Yep, that's what I'm telling you. I didn't write this. Don't get angry with me, and say this is crazy doctrine. I'm just telling you this is the way the law is. So if I want to haul marijuana, here's a couple things you want to keep in mind. There's a thing called the fruits of the crime, or evidence. Don't haul marijuana in your $30,000 Porsche. Haul it in a Hertz car, so that if you get caught, they confiscate the Hertz car and not your $30,000 Porsche. See how that goes? Next, why don't you get rid of the license? That way, when the police stops you because your taillight is out, and that's his probable cause, and then he finds the marijuana, hold it. I'm not a licensed driver. You can't stop me. You didn't have any. You had probable cause to stop regulated persons, but not me. And I told you don't search in my trunk, and the guy searched in my trunk and found the marijuana. Sounds crazy? I don't see that as being crazy. I see that as being exactly on point. If you've got a driver's license and that policeman says, I'm opening your trunk, you volunteered into a regulated and licensed business, and he can search your trunk with certain limitations. I'll grant you there are some certain limitations, but when you're in that regulated enterprise, you don't have the same protections that you have when you're a natural person or a natural citizen. Anyway, going on, the businessman in a regulated industry, in effect, consents to the restrictions placed upon him, as the court stated in Biswell. Do you see where your Supreme Court is telling you? When you get license and privilege, you are consenting into this regulated enterprise. And if you give consent, then you don't have a Fourth Amendment right, do you? See how straightforward, see how plain that is, so easy that is to understand. I didn't write this, so don't say this is 1 Gordon 4:14, because it's not. This is Almeida Sanchez versus United States. Going on then, in the Biswell case, this is a quote then from Biswell, it is also plain that inspections for compliance with Gun Control Acts, or the Gun Control Act, pose only limited threats to the dealer's justifiable expectations of privacy. You have justifiable expectations of privacy. That is, if you're a natural person, but if you're a corporation and the IRS says, we want to see your records and books, you don't have any justifiable expectations to privacy. If you're a taxpayer and you've been filing every year and the IRS says, why didn't you file? We want to see your records and books. Look, friend, you've been volunteered into this regulated industry for years and years, and now all of a sudden you're screaming rights. See where your problem is? That's why when so many people come in, the first thing I want to know, well, let's see, where's your status? What are you? Are you a slave, member, corporation? I've got people come in here, they're in corporate business, and they don't want to stop at the scales. They don't want to weigh their trucks. And I go, well, I used to be in that place at one time. I used to think that I had rights when I had really no expectation to this privacy. When a dealer chooses to engage in this pervasively regulated business and to accept a federal license, he does so with the knowledge that his business records, firearms, and ammunition will be subject to effective inspection. Yeah, you're going to be subjected to effective inspection. Now somebody's going to say, well, what we need to do is change the law so these corporations aren't subjected to this. To that I say, baloney. I want those corporations and juristic persons. I want those police out there to regulate these felons coming out of jail. I don't think I want robbers given their rights back right away. You let a guy out on parole or probation or something, I don't think there's any reason why we should allow him to carry a gun concealed. I don't know that we should necessarily let people go unpunished and give them rights and privileges and well, with basic rights until they've earned them back. You know, there are some real criminals out there. Each licensee is annually furnished with a revised compilation of ordinances that describe his obligations and define the inspector's authority. Well, don't you see that every year with your legislature? Don't they revise the traffic laws? And aren't you every year? Each licensee is annually furnished with a revised compilation of ordinances. They do that in Idaho. They revise our Title 49 every year, and you know, you got a driver's license in your pocket and you're just tooling down the road. You're supposed to know what the speed limit is, and you're supposed to know what the regulations are. And so it's not a matter of rights, you know, when you're talking about driving down the road in a regulated capacity. So says your Supreme Court in this case. In other words, this is called dicta. When you take information out of a case, which is not the central heart, doctrine, and core of the case, which in this case is Fourth Amendment, that information is called dicta, and I'll concede to you attorneys out there, that's right, this is dicta. But with this dicta, I can then go to other cases like transportation cases, such as that 1867 case in Nevada, and pull out the transportation cases and show you that you cannot tax a right. You cannot tax my right on the road. And the court then, when I write my briefs and motions, I'm going to go to those cases that are on point and specific. For instance, the court has ruled that a citizen has no specific duty or responsibility to government, Hale versus Hinkle. And they've told us that you cannot tax a right. They've told us that driver's licenses are taxed and that registration is a tax. And you can't tax a right, and the Constitution is a superior doctrine or document. That's Marbury versus Madison. Now, watch what you do here. You put Marbury versus Madison, Hale versus Hinkle, and I forget that name of the fellow there in Nevada, but I think it was Chandler versus Nevada or something on that order, 1867, that you can't tax a person for using the road. And then you come to Almeida Sanchez, and you put that together, and then reason, logic, and common sense puts your position out as your theory of the case. See how that goes together? And now you've got your theory of the case. If you don't have a position, that's exactly spelled out. Now, if I was hauling marijuana down the road and they searched me, I could go to Almeida Sanchez because this case is exactly on point. But what if it's off just a little? Well, what if it's new ground? What if it hasn't been decided directly, but it's been decided indirectly by dicta from a number of other cases? Does that mean your position shot down? Absolutely not. That establishes your position. So, you see now, this thing of staying on point and being able to look at what the decision was in this case, along with 10 other search and seizure cases, pretty soon you'll recognize the plain view rule. Was the marijuana sitting in the front seat? Was the policeman in a place that he was authorized to be in at the time he saw that in the plain view? Is this a random check, 1 out of 10? Or is this a roadblock that checks every single car that comes through? Those are all positions, or those are all very pertinent facts pursuant to the Fourth and Fifth Amendments. Now, moreover, in column 8, I'm at the bottom of page 266 here, am I not? No, I'm at the bottom of page 271. Moreover, in column 8 in Biswell, the searching officers knew with certainty that the premises searched were in fact utilized for the sale and or liquor or guns. When the fire marshal comes in, he's in there looking for fire hazards. He's not looking for marijuana. And when the alcohol, tobacco, and firearms inspection man comes in, he's looking for guns, and he's looking for ammunition, and he's looking for compliance with law, rules, regulations that this man has voluntarily taken the license for, and he's regulated. Bank examiners going into a bank don't need a warrant. The bank isn't a regulated enterprise. That bank examiner comes in there as just a matter of course of doing business. In the present case, by contrast, there was no such assurance that the individual searched was within the proper scope of official scrutiny. That is, there was no reason whatever to believe that he or his automobile had even crossed the border, much less that he was guilty of the commission of an offense. So, you can sit there and say, well, what difference does it make how we find these crimes out? This guy hauling that marijuana never committed a crime. If you stop and think about it, there was a time in the good old U.S. of A. when there were no anti-marijuana laws, were there? Let's go back to 1895. Did we have some kind of a horrendous drug problem in 1895? Here's no control, no laws, no rules, no regulations. If you want to grow marijuana, you grow it, and if you want to smoke it, you do, or you don't, and who cares? Today we've got all these complex laws and rules and regulations, and this marijuana stuff is pretty expensive, and that's what makes it profitable. You see, if that stuff was legalized next week, I doubt if that stuff would sell for much more than a package of cigarettes. Now, I don't know how good it is or how bad it is. I don't know anything about it and don't really care. All I know is I don't want to be God and tell you what you shall and shall not do, and what you shall and shall not smoke, what you will or will not drink, what you can do or cannot do. That has to be done by responsible individuals. What I want to do is to teach every American to be responsible for his actions. Now, I'm not telling you that I want you to go out and grow marijuana and sell it to my 10-year-old daughter. What I'm telling you, if you want to smoke marijuana, that's your business in life. If you want to drink alcohol, that's your business in life. If you don't want to drink, then you don't have to drink. We went through this prohibition baloney, and I think we found out that all that did was create bootleg, and people are going to drink anyway, and if people want to drink and become alcoholics, I don't really care. It's not my responsibility in life, and I'm not here to try to regulate your life, and I don't want you to regulate my life. I want you to butt out of my life. And if I turn into an alcoholic, that's my problem in life. That's not your concern. You just take care of you, and I'll take care of me. And here's what your court is telling you. Let this guy, if you just left him alone and didn't bother him at all, that's his product in the back of his truck, and he's driving down the road. I don't care if you've got a concealed gun. How does that affect me? I want you to have a concealed gun. I'd like to see every woman in America with a .25 automatic in her purse. And there won't be any more rape, because there won't be any more rapists. It's that simple. You'll have to kill a few of them. There'll be a little blood and gore. There'll be a few ladies shooting their feet off, a few ladies shooting their boyfriends, and there'll be a little blood let in the streets. But once that's over with, one of two things has to occur. Every rapist attacks, bang, bang, rapist dead. We're either going to run out of rapists or reform the rest of them, one or the other. And meanwhile, we don't have to lock them up in prison at $10,000 to $20,000 a year and tax me to create law and order. And no policeman, to my knowledge, has ever prevented a rape. Might happen once in a while. He accidentally comes upon a rape scene. I'll tell you the person who's best able and best capable of preventing rape. It's the victim right there at the scene of the crime. And the way they do that's with a .25, and it's been tried in Florida and tried up in Wisconsin, and boy, it just worked with fantastic results both times. Now let's go on here, page 272, and watch this conclusion. Since neither this court's automobile search decisions nor its administrative inspection decisions, that's two classes of search and seizure cases, provide any support for the constitutionality of the stop and search in the present case, we are left simply with the statute that purports to authorize automobiles to be stopped and searched without a warrant and within a reasonable distance from any external boundary of the United States. Those guys could have stopped your car and searched you. They could have stopped me and searched me. They could have just looked at me and said, hey, he's within 100 miles of the border. Let's search and see if he's got any Mexicans in his van or his station wagon. And I don't want that. It is clear, of course, that no act of Congress can authorize a violation of the Constitution. Oh, listen to that. It's clear that no act of Congress can authorize a violation of the Constitution. Well, if you knew what your Constitution said and how it works and how it applies, then you can see that every time the Congress or some administrative agency passes some rule or regulation, Like, here in the state of Idaho, we have a law in our books that says you can't carry a concealed weapon. I got news for you. There are a lot of people that carry concealed weapons, and they tried to prosecute one of these free men over here and fell flat on their noses, and he carries the gun right into the courthouse. He carries it right into the judge's chamber. Yeah, and he can successfully argue that position, and he can defend it in the courtroom, and he can win each and every time. And if you want to learn how to do that, we'll teach you how to do that. Does that mean then that I think that you should carry a concealed weapon? I don't know whether you should carry a concealed weapon or not. If you're free and if you're 21, can't you decide for yourself whether or not you should carry a weapon? Now, I don't. But it isn't because I can't. It's because I've decided for myself that I don't need to, nor do I want to. But I don't want you telling me I can't any more than you want me telling you you can't. I want you to decide for yourself. And so here's your Supreme Court telling you exactly the same thing. We don't want to run around here searching people just to see whether or not they're committing crimes. You do that to 10-year-old kids. You go in and search your kid's closet or their toy box and say, hey, you didn't pick up all your toys here, little boy, and I'm going to spank you or I'm going to do this or that. Hey, your closet's not police stuff. You go in and you search your kid's room and you see that his closet and his clothes aren't picked up. But there comes a time when you grow up, and when you grow up, then with that comes responsibility, and that's what your Constitution's all about. It's responsibility. That's what it boils down to. But under familiar principles of constitutional adjudication, our duty, here's the duty of the Supreme Court. Our duty is to construe the statute, if possible, in a manner consistent with the Fourth Amendment. And he quotes a couple of cases. It is undoubtedly within the power of the federal government to exclude aliens from the country. Yeah, we can stop them at the border. Aliens can't come in. And here's a case that says, yep, that's right, you can exclude aliens. It is also without a doubt that this power can be effectuated by routine inspections and searches of individuals or conveyances seeking to cross our borders. So checkpoints at the borders aren't unconstitutional. As the court stated in Carroll v. United States, travelers may be so stopped in crossing an international boundary because of national self-protection, reasonably requiring one entering the country to identify himself as entitled to come in and his belongings as effects which may be lawfully brought in. And there's Boyd v. U.S. There's the beginning of the exclusionary rule line of cases. Boyd. You've got that case. Read it and study it. Whatever the permissible scope of intrusiveness of a routine border search may be, searches of this kind may in certain circumstances take place not only at the border itself, but at its functional equivalents as well. So when the airplane lands in Los Angeles, that is the port of entry. And that's where they conduct the search. And that can go on. You come in from Mexico, there's no problem. For example, searches at an established station near the border at a point marking the confluence of two or more roads that extend from the border might be functional equivalents of border searches. For another example, a search of the passengers and cargo of an airplane arriving at a St. Louis airport after a nonstop flight from Mexico City would clearly be the functional equivalent of a border search. You see how the court construes reason, logic, and common sense? So the 100-mile rule doesn't even apply. If you were to apply this strict regulation, you'd have to say, well, you can't search in St. Louis because, the Border Patrol is limited to 100 miles. That's insane. When that plane comes in from Mexico City and lands in St. Louis for the first time, as far as that's concerned, that's the border. Okay? So the court is in effect saying, okay, you executive officers, you don't know how to search on the road. Let's show you how to search. Let's lay down the rules. Let's get the groundwork down here. Now, you policemen, you border patrolmen have to obey these rules right here. And it's when those government agents fail to obey these rules that they violate your rights. When they violate your rights, the issue isn't what you did or didn't do. The issue is rights. And when the rights issue comes in, where rights are involved, there can be no rulemaking or legislation that would abrogate it. I don't care what the Attorney General or the Congress says in regulating or issuing regulations and CFR and all that. The key then for a free man is don't volunteer into those regulated enterprises, and if you do, for whatever reason, don't get angry with the policeman for enforcing those administrative rules. That's the way we see that. But the search of this petitioner's automobile by a roving patrol on a California road that lies at all points 20 miles north of the Mexican border was of a wholly different sort. That's a whole nother ballgame. In the absence of probable cause or consent, what if the policeman stopped and says, "Hi! Hey, do you mind if we search?" "No, go right ahead." You got a lawful search? You bet. And anything they find could be used against it. "Hey, mind if I search?" "Absolutely. Get a warrant." "Don't you search anything. I refuse to give up any of my rights." And that search violated the petitioner's Fourth Amendment right to be free of unreasonable searches and seizures. And so it was unreasonable, that search and seizure. Are there reasonable searches and seizures? You bet. And when you get through 100 cases of the search and seizure law report, you're going to see lawful searches and unlawful searches. Searches that are upheld by the court and searches that are overturned by the court. And boy, are you going to be a knowledgeable person when you get through with a little research like that. There are literally thousands of these cases, and I'm just telling you that by the time you cover 100, you just about got it. You know, you have a good cross-section. Can the government take blood out of your veins? Can an officer pull a blood sample? Schmerber versus California. There's a good case. That'll tell you the answer to that. It is not enough to argue, as does the government, that the problem of deterring unlawful entry by aliens across long expanses of national boundaries is a serious one. So the government says, "Hey, we have to do this, or we can't carry out our job." That's their argument every time. "Hey, we need these searches so that we can carry out our job." The needs of law enforcement stand in constant tension with the Constitution's protection of the individual against certain exercises of official power. If we don't have control over these exercises of official power, then these people are going to say, "Hey, it's necessary to knock your door down and come into your house and search for these illegal aliens." There won't any of us have any privacy or any rights whatsoever if we were to allow this kind of thinking to just, go on and on without bounds. So it is precisely the predictability of these pressures that counsels a resolute loyalty to constitutional safeguards. And so here's your court saying, we have a resolute loyalty to protecting constitutional safeguards. It is well to recall the words of Mr. Justice Jackson soon after his return from the Nuremberg trials. "These Fourth Amendment rights, I protest, are not mere second-class rights, but belong in the catalog of indispensable freedoms. Among deprivation of rights, none is so effective in cowing a population, crushing the spirit of the individual and putting terror in every heart." Listen, they've got cowed individuals living in Poland. That puts terror in every heart in that land because they don't have that Fourth Amendment protection.